the privilege of facilitating the conversation on this topic today of the role of regulators in law enforcement and litigation. Joining me is certainly a highly credentialed panel, if I might say a well-balanced panel too. We have representatives from the regulators ASIC and the ACCC, of course the Solicitors branch of the profession, and also the bar. In particular, representing the regulators, we have Wendy Peter and Michael Kingston. Wendy is General Counsel at the ACCC and Michael is the Chief Legal Officer at ASIC. Giving us the Solicitors' perspective are Ross Freeman, who's a partner at Minter Ellison, and Matthew Blunn, who's the Group Leader of the Australian Government Solicitors Dispute Resolution Group. Matthew is actually a late replacement for David Ablett and has flown in at late notice this afternoon from Canberra, so thank you, Matthew, for making the effort to get here. Certainly last but not least, we have the representatives of the bar, Michael O'Brien SC and Fiona McLeod SC. As you might appreciate, with only 45 minutes to discuss this topic, probably 40 now, thanks to the preceding group, and such a large topic to get across, we won't have the chance to talk about all of the things that people might be interested in, but there will be an opportunity, hopefully, for questions at the end, and I do encourage you to participate by asking a question if you'd like to do so. If I can kick things off, Wendy, with you, and a question I think in relation to an issue that may be not so well known to those who don't practice in this area regularly, and that is a question in relation to the thresholds that need to be satisfied before agencies such as ASIC and the ACCC commence litigation. Can you tell us from an ACCC perspective, firstly what those thresholds are, and secondly how they influence the regulatory litigation that's brought by the ACCC?
Thanks, Justin, and I'm not sure, I hope everyone can hear me. And I should say, of course, it's Norman O'Brien, not Michael O'Brien.
Oh, I'm sorry about that, Michael.
He's probably doing the Harper review as we speak. So at the ACCC, we have about 160,000 complaints that come through the ACCC Info Centre and through various other forms each year. And some of them relate to the Competition and Consumer Act. Of course, many don't, and they're referred elsewhere. And ultimately, that results in about 550 investigations. The investigations may be just superficial and identify that there's no issue under Competition and Consumer Act, or they may be in-depth, and in fact each year there are about 140 that are judged to be in-depth. Why do we conduct those particular investigations? Normally it's because the matters within the ACCC priorities. The priorities are set in a strategic review annually. They're published on the ACCC website. They're clearly signalled to the practitioners in the area, and hopefully those practitioners are signalling to their clients. As part of the process of those 140 investigations, there's an oversight by one of the ACCC committees, the Enforcement Committee. That meets every Thursday afternoon at 2:30. Unfortunately, those meetings do tend to go for quite a while, and it can sometimes be 5 or 5:30 by the time the 7, sometimes 10 papers each week are reviewed. Those proceedings are quite remarkable. They involve 6 of the 7 commissioners, the full-time commissioners. They involve all of the 9 officers at the ACCC being hooked in by video. The proceedings are actually broadcast by something that's known as EC radio, so that every member of the ACCC staff can listen to the proceedings if they wish at their desks. And the senior staff are there, the enforcement teams who are presenting each matter, of course, are there, and there is incredibly robust debate on the progress of a matter. And in the lifetime of any investigation, it would normally come back to EC 3, 4, 5 times, sometimes more, for review, for comment, for refocus. So there is a real in-depth oversight of those matters, and of course, in between times, the teams are investigating those matters using the enforcement toolkit the ACCC's got. So by the time something is coming up for consideration as to whether proceedings should be issued, there's been a lot of work done. People have invested a lot of time. Usually the case is well understood. The evidence that's available has been tested. But the ACCC, in order to issue proceedings, has an internal process, and that is it must be considered by the full commission. So it goes to a commission meeting for discussion. And normally at that commission meeting, the paper that's presented to the commission includes as an attachment the advice that's been obtained from external counsel confirming that the ACCC has reasonable grounds to issue the proceedings. That's a requirement that we have under the Legal Services Direction that's issued by the Commonwealth. So by the time we're actually commencing the proceedings, we've really reviewed the matter substantially over the period of the investigation. Of course, that may only be a few months. Normally, unfortunately, it's a bit longer. And we are really prepared to issue. But we also have an obligation to consider alternative dispute resolution, and it is our common practice to engage with the potential respondents, talk to them throughout the investigation, notify them of the ACCC's concerns, and hopefully then there are no surprises when we do issue. The result of that sort of coming in at the hopper of 160,000 complaints is that the ACCC issues approximately 30 proceedings each year in the federal court and resolves another 30 or so matters by way of enforceable undertaking or infringement notices. So that's our process.
And Michael Kingston, from you, from an ASIC perspective, are there many differences in terms of the process, and particularly, say, in relation to ASIC's criminal or administrative litigation?
Well, that's probably one point I was going to make. As Wendy was saying with the ACCC, ASIC of course gets a huge number of reports of misconduct, and the vast majority of those, for a whole raft of reasons, do not result in litigation or even other forms of enforcement action. So there's a filtering process with us, largely driven around our two principal statutory objectives really, which are informed and confident investors and financial consumers and fair and efficient markets. There are other related aspects, but principally driven by that. And when we're thinking, having taken a case on, do we go to litigation, we're not just thinking, does it justify litigation, is it appropriate to bring it? We're also thinking about the other options available to us. Enforceable undertakings can be entered into. We have infringement notices in a number of areas now that ASIC regulates, which are people say they're a bit like a sort of an on-the-spot fine, but they really are a statutorily prescribed form of settlement, because they're only paid if the person we issue them to chooses to pay them, and then it results in the matter being resolved and no further action being able to be taken. And our administrative process, which can result in people being disqualified from managing corporations, effectively banned from the financial services industry, effectively banned from the credit industry, or losing their relevant licences in those two industries. In terms of thinking about thresholds, especially to bring process in the courts, when we've got to start with the legal services directions, which obviously apply to the ACCC as well, and they do say we're not allowed to start a proceeding unless we've received written legal advice from lawyers whom the agency is allowed to use in the proceedings, indicating there are reasonable grounds for starting the proceedings. That reference to lawyers we're allowed to use refers to the fact that without special permission from the Attorney General, an agency's internal lawyers can't represent it in litigation. Now ASIC has that permission, so we tend to act as solicitors on our own matters, not always, but more often than not. We also have internal rules for when we might start litigation, which rules or guidance is probably fairer to say. And that is, normally we will have obtained in admissible form sufficient evidence to prove the case in relation to a civil penalty proceeding, or where that's not practicable or reasonable in the circumstances, have a high degree of confidence that such evidence can be obtained without undue difficulty or delay. We also have to have considered plausible alternative explanations for conduct and likely defences. We've got, and I won't go into it conscious of the time, but some particular guidance about what we need to check and think about before in a civil proceeding we allege dishonesty. In relation to the decision making to start a proceeding, it would in most matters be made by one of the enforcement senior executives, who are one of basically 4 senior people within ASIC who run the enforcement teams, in consultation with the relevant commissioner. But for significant matters, those decisions are made by either the Commission or the Enforcement Committee, which is comprised of commissioners, those enforcement senior executives, me, and a couple of other people. Also, unless the Commission otherwise decides, a lawyer in the Chief Legal Office needs to approve the commencement of all civil litigation. The one other thing I'd mention, picking up on the criminal, is not all our matters obviously can result in either civil penalty or criminal charges. Some are purely criminal under the law, some are purely civil penalty. Many in fact, don't result in either of those outcomes. But when we're proposing to commence a civil penalty proceeding, we're obliged, unless we think there's no evidence which would support an indictable charge, to consult with the DPP about whether the matter should instead proceed by way of criminal proceeding. I think that's very sensible, but it actually results from a ministerial direction both agencies were given back in 1992 when we weren't cooperating as well as we do now, and when there was some concern, I think at the time, at least on the part of the DPP, that ASIC was overlooking criminal charges and focusing too much on civil charges. Hence that, I think, quite appropriate consultation before we bring civil penalty proceedings.
And Matthew, Blunn, to you, are there any substantial differences dealing with the other regulators, APRA and Customs and so on, that the AGS represent?
I wouldn't say substantial, no. What I would say is that having heard from the two of the larger Commonwealth regulators, both Wendy and Michael have referred to published enforcement policies and priorities from the perspective of a solicitor acting either for the regulator or against the regulator. It's very worthwhile pausing to review those documents if you're acting in a matter concerning a regulatory enforcement proceeding. Reference has been made to the LSDs. The only comment I'd make two comments in relation to the LSD so far as other agencies are concerned. It's worth pausing to remember that the LSDs don't apply to all agencies. The vast majority are required to comply with the LSDs, but there are some strange Commonwealth entities, some of whom do have regulatory functions that are not caught by the LSDs, and in fact the Department of Finance publishes as a very useful flip chart, they call it, of agencies which are caught and are not caught, so it's also worth pausing on that. In relation to the requirement that there be reasonable grounds, at the risk of telling you all how to suck eggs, it is very, very important to remember, if you're either acting for a regulator or against a regulator, that there is a material distinction to be drawn between reasonable grounds and reasonable prospects, and it is very important to remember that a regulator does not need reasonable prospects in order to institute proceedings for a whole range of very good policy reasons.
So just picking up on that difference there, reasonable grounds and reasonable prospects, Ross Freeman and Fiona McLeod, from your point of view in terms of, advising defendants who might be the subject of these sorts of regulatory actions, are the threshold considerations relevant when it comes to the way you go about advising your clients? Ross, you first.
Yeah, sure. Well, they are. You need to be very aware of what the thresholds are and frankly, how strong the case is that your client faces. Often, if you've been involved in the investigative phase acting for your clients, you've got a pretty good idea what that might look like. But if you're not, you do need to get on top of it quickly. And obviously, a client facing regulatory action in the courts, it's a pretty big deal for anyone, whether they're a company or an individual. The thing you need to tell your client, though, is that any plaintiff, whether it's the regulator or a private litigant, is most in love with their case when they first issue proceedings. And you need to understand that there's a long way between the commencement of proceedings and an outcome often, and the view that the regulator may have about its prospects, but more particularly the outcomes, need to be shaped during the course of the proceedings. So you can obviously go into proceedings. You might tell your client that their prospects are reasonable defending the matter, but really part of the end game is winding back a little bit the expectations of outcome that the regulator might have, which your client thinks are unreasonable. So you do have a job in bringing it back perhaps to closer to where your client expects the matter to land.
And Fiona, from the barrister's perspective, anything to add?
Well, of course, we can be acting for regulators and
Of course.
directors. So what's been said about regulators' considerations are important. When you're acting for a regulator, you have to turn your mind to the legal services direction for the Commonwealth, or in the state context, the model litigant guidelines. You have to turn your mind to the reasonable prospects and the availability of admissible evidence. And you have to turn your mind to the question of public interest. And there's some very good guidelines, I'm aware, on the ASIC website at least, about what that public interest means. If you're acting for a client who's coming head-on with one of these regulators, it's a good idea to look at those, because there's an opportunity to negotiate at this point around that topic of public interest and what is a better outcome pre-issuing. In the context of class actions, the regulators have been pretty slow to pick up the powers to issue class action proceedings, and that might reflect their view about where the public interest lies, particularly now that you've got the emergence of the upstairs group talking about litigation funding, and there's a sense that the private profession can take the risk and the cost of running class actions. Regulators don't need to. So I'll say something in a minute about the complementarity of those proceedings working side by side, but I just want to mention in terms of public interest that that's a whole range of things that it's useful to have in your armoury, because it's not a defined concept, and it's really a matter of regulators looking at their objects and purposes. Does this litigation fit their strategic objectives for the time being? They won't just issue proceedings because, you know, there's necessarily someone to take on. They might try and secure an enforceable undertaking or an outcome like that if it's a quick and dirty outcome. If it's somebody there's an issue out in the public domain that needs seriously addressing, or there's a high-profile person perhaps involved, they might be more inclined to take the action that involves issuing of litigation. Just a couple of other things relevant to public interest. Those include the extent of the losses, the size and composition of any potential class, and the vulnerability of that class. So in Money for Living, for example, you had a group of retirees who were all investing in reverse mortgage type products. That might be a class you'd consider weighing in as a regulator, whereas if you've got tax minimisation schemes, the regulator might be more prepared to say, well, an external administrator can sort it out, I'm going to leave it up to them. There's also prospects of recovery, the nature and cost of proceedings and the internal resources required, and the interactions with criminal processes. So, for example, if you have a need to quarantine a criminal team who are working on criminal aspects, it might be just too difficult to try and quarantine out the material you're obtaining from the use of coercive powers. You might not want to have two separate teams divide out and split your resources that way. There might be delay through criminal proceedings to civil proceedings, so that might affect the way the regulators look at it. And then there's also the question of what use is there in the findings. There has been a tendency, I think, in many cases to just get in and put in the external administrator, let them work it out. ASIC have done their job, or the ACCC in some cases I'm less familiar with, but they just want to get in and get that quick result. And that is, again, comes down to who ultimately is going to carry the burden. And that's useful to bear in mind if you're acting for directors, because you can go in and negotiate that sort of outcome relatively quickly and then deal with the leftover.
Thanks, Fiona. Michael, if I can come back to you and just change tack slightly. Often one of the most intimidating aspects, I guess, of regulatory action is the compulsory examination and the coercive powers that the regulators exercise. Can you talk about the circumstances in which there's a tension between the use of those compulsory powers on the one hand and then the commencement of litigation on the other, in particular in, say, an ASIC context where we see the need to consider urgent injunctive action to freeze assets, and then balancing that on the one hand with the need to continue investigating on the other?
I suppose I'd say, to be honest, we don't normally see that tension arise in practical terms. I mean, it does occasionally, but not particularly often, although theoretically it can be there. The tension is the concept that the use of at least most of our compulsory powers under the ASIC Act principally run the risk of being in contempt of court in relation at least to proceedings that have commenced on the basis that they represent an unfair or uncontemplated advantage to ASIC that could not otherwise have been obtained using normal court procedures. I suppose one thing I'd say about that, and the reason why it isn't normally a point in practice, is that in most of our matters we generally issue proceedings or encourage the DPP to recommend the laying of charges when our investigation is complete. We don't normally, of course there are exceptions, try and bring proceedings at an earlier stage, and hence we don't see ourselves needing to sort of run around, continue to investigate the person we've taken proceedings against. For us, perhaps being conservative, we tend to draw the line, not always, but as a rule at the time when we have made the formal decision to bring those proceedings or the DPP has recommended the charges. There is certainly an argument to say, and I'm not saying there's a black line in any case, but the line might be crossed more when the proceedings are issued or the charges laid, but we, at least as a practice, tend to adopt a point slightly earlier than that. Now, the position can be different if we're seeking to protect assets, and we've brought a proceeding not by way of interlocutory injunction, which is generally not what we do, but under section 1323, the ASIC Act, which doesn't involve commencing proceedings aiming to penalise a person at whom they're aimed. It is just a protective proceeding which will drift to an end when the orders are released or some other order is made about the assets that have been frozen. So, at least in our view, that doesn't normally give rise to that tension. The position can be different if we wish to pursue the defendant in the proceedings about unrelated matters, matters unrelated to that in relation to which we've started the proceeding. We may then still seek to use the compulsory powers in that case. We'd need to be careful about the way we did it, but we think we could in that case. And there is authority to support the view that even though we've issued proceedings, we can still keep talking to other people who might have been involved in misconduct with a view to seeing if proceedings should be brought against them, even though it may have the incidental purpose of giving rise to evidence which could be used in the proceeding that we've commenced. It's also possible the position is difficult in relation to corporations as they don't have the benefit of penalty privilege or privilege against self-incrimination. And I would just mention in relation to ASIC, we do have a couple of compulsory powers which are specifically contemplated to be used once proceedings have commenced, and that's the reasonable assistance provision in section 1317R of the Corporations Act and in relation to just criminal proceedings, section 49 of the ASIC Act. Now, we can't use those against defendants or their lawyers. People will be relieved to hear. We do tend to use them from time to time to request further documents.
And Wendy, in the ACCC context, whether certainly the legislative regime in relation to compulsory examinations is slightly different, is there any difference in practice?
Probably not in practice. The Section 155 contains the powers, the ACCC's investigation powers, and there was some debate about where the line was, and the legislation was amended several years ago now to introduce Section 155 subsection 4, which makes it clear that the Commission can use those powers up to the time it commences proceedings. It's intended that it would also allow the Commission to continue to use those proceedings if it was seeking an interlocutory injunction, although I'm not sure that the draftsperson actually achieved that. So generally, as a rule, the ACCC will stop using those powers once it's issued, issued proceedings.
Yeah, thank you. Norman O'Brien, you've been senior counsel for ASIC in some very high-profile cases. At least one of those cases involved the overlap of civil penalty proceedings on the one hand and a criminal investigation that had been recommended by a Royal Commission on the other. Considerations arising from overlapping jurisdictions is something that seems to often arise in this sort of regulatory context. Can you tell us how that overlap of jurisdictions had an impact on ASIC's civil penalty proceedings in that case that you were conducting?
Well, perhaps let's talk in a broader context, Justin, but hopefully this will also answer the question you've raised. My experience is, and I think I've actually done many more cases for the ACCC than for ASIC over the years, but in any event, I've done a few for both of them and won a couple every now and again. The most important issue that arises in these cases, and it's a very, very important issue for all of us in practice, is where civil penalties are sought. And I include in the category of civil penalties the banning orders that Michael was talking about earlier, which are available, of course, in a number of ASIC cases because the decision in ASIC and Rich made clear that those sorts of orders are also in the nature of civil penalties. And so, of course, the civil penalty, the privilege against any self-exposure to a penalty and allied to it the privilege against self-incrimination if there is any possibility of a criminal process running alongside or afterwards become very important. And My experience is that it's the interaction of those principles which provide, a very effective bar in favour of the defendant, the natural person defendant, although in some circumstances also the corporate defendant, because whilst, it is an essential part of our understanding of the law of privileges in these contexts that corporations can't claim them, there is, of course, the possibility that a corporation can effectively rely upon them in circumstances in which the only source of the information that the regulator is seeking to obtain, whether it be by getting a defence or getting particulars or getting documents or taking other interlocutory steps, if the only source of that information is an individual who has the benefit of the privilege, then for practical purposes it will be unenforceable against the corporation as well. So that's a very significant area of debate. It's a very developing area in our law. There have been decisions even in the last couple of weeks. In Victoria, for example, in the Gemmell case, which I'd urge you to read, a very interesting decision of the Victorian Court of Appeal addressing the intersection between the effect of that privilege in circumstances in which a liquidation had occurred, there'd been compulsory examinations, certain privilege had been taken and not taken in the course of the answers to questions in that compulsory examination. Subsequently, the liquidators brought proceedings seeking recoveries from the relevant directors. Those sorts of proceedings can often be followed by proceedings for pecuniary penalties or for banning orders. And therefore, despite the fact that ASIC was not directly involved in any of those proceedings, because at the investigatory stage it was simply a liquidator exercising powers of compulsory examination, the litigation as it came before the court, and it was before the Court of Appeal only a couple of weeks ago, didn't involve ASIC at all, but nevertheless a very interesting discussion of the operation of the privileges vis-a-vis these directors who are the subject of the civil proceedings by the liquidators and who had faced the compulsory examinations and in many instances forgotten or decided not to claim their privileges. So I would recommend you have a read of that because it informs, it's a very good summary of the law apart from anything else in this area which continues to develop, but it also explains the interesting tension that arises in most, if not all, of these cases that I've been involved in. And that's, of course, because fundamentally the regulators are interested in deterrence. That's why they take on these proceedings. They're interested principally in specific deterrence of that particular defendant or group of defendants, but more importantly from a policy perspective, as both Wendy and Michael have identified and as we're all well aware, the principal objective of the regulators in all areas of activity, so far as the litigation is concerned, is general deterrence. And so, of course, they'll seek a range of remedies which are designed to achieve that objective of general deterrence. The penalties will be part of it, but of course there'll be a range of other remedies that will be sought in the typical proceeding.
Thanks, Norman. We heard in the last, Fiona, session about class actions, and there was a particular focus, of course, on the bushfires class actions, which is a topic that's close to both of our hearts. But we also heard about the way in which class actions are beginning to permeate, I guess, into the regulatory space, particularly in a shareholder class action perspective. From your point of view, is this a good thing? And in particular, are there any advantages, I guess, that plaintiffs enjoy in a class action context which may not be available to the regulators when they bring their regulatory litigation?
Well, very much is the short answer. We have a regulator bringing a class action, and there haven't been many of those. That's particularly a case where you can get both interlocutory findings and outcomes that give momentum to a way cases are resolved ultimately, but you can also get in regulators' class action short, sharp findings, if you like, that then can feed through. We've been all talking about commissions that can often precede these class actions, and the commissions may be initiated by a regulator, they may be initiated by government, but those that harnessing of the evidence ahead of a class action initiating a very, very useful process. They don't give you necessarily admissible evidence, but they focus in on certain topics. So there is very much a place for the complementary action the regulator kicking off, getting some early goals, getting some short, sharp outcomes, and then having those findings feed through. I just wanted to pick up a point Michael said earlier about the contempt issues. I think it was in Crown Star, was one of the travel holiday scheme cases. There was an issue about, after the injunction was achieved, there was an issue about we wanted to issue, or ASIC wanted to issue a search warrant. And there was no issue provided the court was continually involved about what steps were to be taken. And I think that was a similar approach taken in the Henry K matters and the West Point matters. So long as the court was fully engaged in the process and knew what was happening, there was no contempt of the court, if you like, and no view that there was an improper use of those coercive powers after the initial proceeding was issued. In Money for Living, it was an added bonus because after the class action was heard and determined, the trial judge, Ray Finkelstein, invited ASIC to come back and appear as amicus for all the other little side spats, which is always good for the bar because then you get on going fabulous work. But there's the fact that you can use the findings of fact and law in the class action under 12 GG, I think it is, of the ASIC Act, in subsequent actions that were so very useful, and of course all the outcomes that you've got negotiated along the way in terms of findings of fact, findings of law, momentum, so that directors might give up on an aspect that they might have otherwise fought if it was the first time you're looking at an issue.
And Ross, from your point of view as a solicitor, related regulatory action, are there any instances where it has an influence, I guess, on the way that the civil class action plays out when there's been particularly where there's been initial regulatory interest in a matter?
Yeah, I suppose the first point to observe is that if it becomes known that ASIC's investigating a matter, it does generate a degree of excitement amongst the plaintiff lawyers for two reasons. First is it tends to lend a little bit of credence to their class action or their proposed class action, and I suppose it might make it a little bit easier to get their class together. But secondly, the fact that ASIC's investigating a matter, class action lawyers know, and everyone knows, that that's going to involve the gathering of quite a lot of material, either informally or formally, by ASIC with respect to the investigation. And although ASIC's under an obligation to keep material confidential, and that obligation's in the ASIC Act, you do need to advise your clients that it's very likely that a lot of that material will end up in the hands of the class action lawyers either before the proceeding starts or during the proceeding. And what they'll get are not just documents that have been produced, but also examination transcript. And examination transcript can be that of directors or executives of the company for whom you're acting. And that's quite unusual to get effectively deposition material in the context of civil litigation, but there it is. So you need to tell your clients, and particularly executives who might be examined, that whatever they say in their examination is likely to be read by class action lawyers down the track if a class action materialises. Now, that obviously doesn't change what they say in response to ASIC's questions, but it does mean that the extent to which a company might be prepared to voluntarily provide information to ASIC is a little circumscribed, because anything you volunteer to ASIC itself might be handed over to the class action lawyers, either because of a subpoena which is served during the course of the class action or because of the operation of Section 25 of the ASIC Act. Now, that section allows ASIC to share with another party who's either carrying on or contemplating in good faith a proceeding in respect of a matter to which the examination related. So it does mean that either through the subpoena process or Section 25 process, the working assumption is the class action lawyers will get the material. And I think it then raises two questions for a company which is the subject of an investigation. First is if it's thinking of trying to resolve a regulatory matter with say, ASIC. There's obviously a desire sometimes by a company to cooperate and give material up to ASIC as soon as possible to try to engender a spirit of cooperation, get an outcome. But the tension there is that that's obviously not necessarily a good idea with respect to the class action if it certainly broadens the scope of material that might be available. Secondly, you'd need to be aware that sometimes in an investigation, it's often the case that executives who might be examined by ASIC are subject to confidentiality directions, so they can't share what information they've about their examinations with, say, the General Counsel of the company. And you just need to bear in mind that if you end up in a class action situation, you might want to, and you're acting for the company, you might want to ask ASIC, with the consent of the examinee, for permission to read the transcript so that you know, ahead of the class action lawyers, what's in the examination transcript and be prepared for any surprises. So I think there's a lot there, and ASIC does become a very convenient collection agency for class action lawyers.
Yeah, well, certainly the issue of confidentiality is an important one, and it's one that I'll come back to you on in a moment, Matthew. But before I do that, Wendy and Michael, from an ACCC and ASIC perspective, just broadly, do you think class actions are complementary to the work you do as regulators? Maybe Wendy, you first.
Sure. Yes, we do. And I think they've got a real role to play in enabling businesses and consumers who have suffered loss as a result of anti-competitive conduct to obtain compensation for that. There is, however, a slight tension, and the position with information obtained by the ACCC is slightly different, I think, to the position with ASIC, and particularly in the cartel space, which is where we've had our main experience with class actions. Our Act now contains provisions which have the concept of protected cartel information, and that's being done to enhance the immunity policy that the ACCC has in relation to cartel conduct, to encourage participants in cartels to be the first in the door to seek immunity, to obtain a marker and seek immunity, so that they will have immunity from ACCC or CDPP prosecution for that cartel conduct. And that's granted on condition that they cooperate fully, provide documents, provide evidence to the ACCC, which is shared, if appropriate, with the CDPP. So there is a tension between encouraging immunity applicants to come through the door, in fact race through the door to be the first in the door, and the concept that all of that information might be handed over to class action plaintiffs. So I think there is an ongoing tension in terms of cartel conduct. And the other issue I think that is ongoing tension is the balancing between availability to the ACCC to settle a matter on the basis of an agreed statement of facts that's put to the court to assist the court to make findings or rather to make orders in relation to penalty and declarations and injunctions and the like. And at the moment, Section 83 of the Competition and Consumer Act does not allow those agreed statements of fact to be used as prima facie evidence, whereas it does allow findings of fact made by the court to be used as evidence in subsequent proceedings. And there is a real push by class action plaintiffs in particular to be able to use those agreed statement of facts, and that's a recommendation that's contained in the Harper report that was issued a few weeks ago. I think we'll have to see where that goes, because it really is one of these balancing different policy objectives. Who bears the burden of needing to prove these cases? Does the class action plaintiff need to do that in their own proceeding, or does the ACCC need to run a lot more cases, because it would be a great discouragement to settlement?
And Michael, the ASIC view, particularly with the rise in the shareholder class action and to a lesser extent, I guess, consumer protection as well?
Look, I think it's fair to say that ASIC's view about when it should seek compensation on behalf of investors has varied over the years, and to some degree depending on who's sitting on the commission. And I think at the moment we would regard taking compensation proceedings as exceptional, which is not to say we wouldn't do it from time to time. And although it's rarely taken the form of a class action, I think there are sort of quasi-class actions in terms of our ability to take action under Section 50 of the ASIC Act or 1325 of the Corporations Act, or the other odd provision where we're effectively seeking compensation on behalf of a large group of people. They're individuals, they have to consent to that occurring, but nonetheless. And what we did in relation to Storm Financial, where directly or indirectly through our efforts, about $250 million of compensation has now been recovered, is an example of that. But it will be unusual. And that is in part, I think, because of the rise of class actions. I was looking at a report from 1969 by Richard Eggleston, where he was saying the reason a government agency needs to be able to bring proceedings on behalf of people is because of the relative poverty of those affected and the inability to organise financial support for the litigation. Well, a lot of people would say class actions are the answer to that, which is why I think for the time being, yes, we'll still sometimes do it because the area might be really tricky, risky, novel, and no one's rushing in to do it. I think, to be honest, Storm was an example of that until a smaller firm, not being at all pejorative to saying that, but not a normal player in that space got in after we'd issued the proceedings. But it will be unusual. I think, by and large, it can be a good, not cooperative, but the two pieces of litigation, civil penalty and compensation through class actions, needn't be obstructive or get in the way of each other normally. As has been mentioned, ASIC can, through subpoenas or applications under Section 25, be a source of information. That's not always straightforward, and sometimes class action lawyers say, why are you refusing to hand this over? We had a fight on multiplex where we were claiming public interest immunity in relation to documents because there'd been a whistleblower involved, and people sometimes say, well, ASIC, you're not being sufficiently facilitative, but we do have to be careful about handing over people's information. But by and large, I think we see it as potentially a useful thing, recognising it can affect our ability to compromise proceedings with people because of their fear of the class action consequences. And that can also mean our ability to compromise where we agree a whole new compliance arrangement with a person, which we'll often think will be a very useful outcome, but the company may be reluctant to sign up to that because of the implied admissions or at least encouragement it might be giving to a class action when that comes. But I just think we have to live with that, and generally we can, overcome it to some degree.
Sure. Matthew, to come back to you, and just both Ross and Michael now have raised this issue of, I guess, confidentiality in the context of the information that's gathered in the course of an investigation. We often, of course, see circumstances where witnesses in particular are happy to help regulators during the confidential investigative stage, but then even in a regulatory litigation context, when it comes to those witnesses giving evidence in court, all of a sudden they become, less helpful. Can you tell us about those circumstances and the approach the AGS takes to handling that issue of confidential information?
Yeah, thanks, Justin. This part of the talk could be entitled Poor Me, or alternatively, It's Not Me, It's You. Confidentiality does raise very serious issues, both for our client agencies and us acting for regulators. The problem really arises, I think, first of all, in the context of the investigations that regulatory agencies carry out, and as you would all appreciate and be keenly aware, the ability of regulators to carry out their function turns very much on the ability to gather evidence in relation to conduct that's been engaged in markets, and there are various means that can be obtained, either through compulsory notices or very often through cooperation of market participants who have been adversely affected by particular conduct. And at that stage, market participants who are being adversely affected are very happy and willing to hand over their sensitive commercial information to assist the regulator come to a view about whether proceedings should be commenced or not. The rubber hits the road, of course, when proceedings are commenced and the regulator seeks to rely on the commercially sensitive information in the context of the litigation, and invariably, notwithstanding the attempts that have been made to consult market participants and the owners of the information as to the consequence of that, invariably those market participants and the providers of the information become very nervous and unsure about that process. And the big point, which I think is not clearly understood obviously by market participants, but very often overlooked by their legal representatives, is, of course, that the commercial sensitivity of the information has nothing to do with the regulator bringing the proceedings. And so the regulator is simply not in a position, subject to the very limited ability that Michael referred to earlier of running a public interest immunity claim, and there are very, very limited circumstances in which that might be run. But broadly speaking, the assertion and maintenance of confidentiality over material is up to the owner of the material. And while the regulator and while the solicitors acting for the regulator will work very hard to try and assist and cooperate in protecting that information, because If we don't do that, very obviously that'll have an impact on the preparedness of market participants to engage in the investigation process up front. So we're very, very anxious to do whatever we can to assist, but ultimately the court will require evidence from the owner of the information to assert and maintain the confidentiality claim. So it's a fraught area of litigation for a regulator, Justin, and it presents real difficulties for us, I have to say.
Thanks, Matthew. I'm sure everyone agrees there's been a number of, thought-provoking pieces of information provided there. Is there any questions from the floor? We are up against it time-wise, but I'm sure we could squeeze one, possibly two in if anyone wanted to ask a question. No? All right. Well, can you please join with me in thanking our panel in the usual way? I think it's now time for afternoon tea.